has a green card for the United States, Your Honor. He has been unable to work. He has been very sick and has had sort of untreated diabetes, Your Honor. So that would be our request for a signature bond for him to be transferred to Brookhaven.
Was there any contention by the state that he had drugs as well? Excuse me.
No, Your Honor.
Just the pipe itself.
Yes.
All right. What is, and he has a hold. What is the hold? I'm sorry. I heard you both mention it in passing. What is the hold that he has?
For disorderly conduct last year.
For last year. All right, at this time, I'm not going to modify his bond. He'll be reset to the SAP calendar on April the 12th of 2022. As a condition of that $1,000 surety bond, he must also stay away from that address on Morosco Drive and have no alcohol, drugs, or weapons. Is there any further questions from either party?
No, Your Honor.
Your Honor, thank you.
All right, best of luck to you, sir. Who do we have next?
I'm sorry. Next, we have position 4, Mr. Cross. Mr. Hatchu, go have a seat over there to the back. You're done. Yep.
Can I go?
Yep, you're gonna have a seat in the back for me.
All right, good afternoon, Mr. Cross. Your case number is 22 CR 0018058. And what's your
Get about this salt, Chair.
all
This
right?
is Mr. Cross.
Okay, are you are James Cross, sir?
Yes, ma'am.
Okay, Mr. Cross, your case is 22 CR 0018058, in which you're charged with criminal trespass. With an offense date of March the 29th of 2022. I've explained your constitutional rights. Do you understand them?
Yes, ma'am.
Do you object to me speak? Can I speak to you by video today?
Ma'am.
And do you have a problem with your attorney, Ms. Wanda Gant? Good to see you, Ms. Gant, assisting you by video today.
Hi, Ms. Gant.
I'm sorry.
I just speak to Ms. Gant.
Can Ms. Gant represent you by video today?
Yes, ma'am.
Thank you. Mr. Howard?
52 total. I counted over at least 10 parole violations. Last arrest was November 2020. Felony theft by receiving, driving without a valid license, possession of cocaine, on probation for that in Cobb County.
All right. I think that's good. Unless, is there anything particularly violent in the last 10 years?
Mostly parole violations, to be honest with you.
Okay. All right. Ms. Tortorello, is it your case?
Yes, Your Honor.
Good to see you, Ms. Tortorello. What is the state's recommendation?
Yes, Your Honor. For the criminal trespass, recommending a $1,000 surety bond. The conditions is that he stay away from the Garnet MARTA station located at 235 Peachtree Street Southwest in Atlanta. No weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, on March 29th, 2022, an Officer H. Smith of the MARTA Police Department was conducting a security sweep and observed the defendant, James Cross, on the stairs, which was an unauthorized area of the Garnet MARTA station. Again, the location was, for the record, 235 Peachtree Street Southwest. The area was clearly marked with posted signage, and it was a restricted area. And all these events did occur in Fulton County, Georgia. Your Honor, the state would be inclined to give a signature bond. However, the state is concerned. He does have an open case, which I'm about to share with you and opposing counsel. I do not want to put this on the record given the nature of the offense. Just bear with me.
Okay.
Yes, Your Honor. And let me share it with Ms. Gant. Give me one moment, please. And due to the fact that he has this open case, he has 51 cycles on his record. He also has felonies on his criminal history, Your Honor. He does pose a risk of reoffending. And so for this reason, Your Honor, I do believe a $1,000 surety bond is reasonable for this matter.
And to clarify, he was standing on the stairs that were closed within the MARTA station. Is that what was the allegation, Ms. Tortorella?
According to the facts, Your Honor, he was sitting on the stairs, and that was an unauthorized area to be in. And it was
Okay.
marked with signs.
Okay, thank you. Ms. Gant.
Thank you, Your Honor. Mr. James Cross is 62 years old. He has been in the Atlanta area his entire life. He has family here, including uncles and cousins. Your Honor, Mr. Cross is residentially challenged, and we are engaging social worker services to assist with housing resources. We are unopposed to the stay away at the 235 Peachtree Street MARTA location. Mr. Cross obtained a GED. He has been unemployed for the past 4 or 5 years. Therefore, he will not be able to make any bond, Your Honor. For these reasons, I am requesting a signature bond on his behalf. We did not hear about any convictions of violence. And the open case, he is, of course, presumed innocent. Again, Your Honor, I'm requesting that signature bond. And again, we're unopposed to the stay away. Thank you.
Now, Ms. Gant, you said that you were requesting some resources via a social worker. If he receives a signature bond today, will you still be able to get those resources to him?
Yes, Your Honor. I told him during our hearing about the Presbyterian Church that he can use for mailing address. He states that he's familiar with that
Okay.
facility.
All right. At this time, defendant's going to receive a $2,000 signature bond through the jail. He is to stay away from the Garnett MARTA station in its entirety, and he is to have no weapons, drugs, or alcohol as a condition of this bond.
Thank you, Your Honor.
Is there anything further?
Nothing further from the state, Your Honor.
All right. Best of luck to you, Mr. Cross. Don't go back to that MARTA station. You understand?
Yes, ma'am.
All right. Who do we have next?
Position number 1, Your Honor, here in courtroom 3. Position
All
number
right. I
1.
don't believe courtroom 3 has heard their rights. So I'm going to say them again. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at this time, at this particular proceeding. And you are Stephanie Lauren Arp.
Yes, ma'am.
Ms. Arp, your case is 22 CR 0018018, in which you're charged with criminal trespass with the offense date of March 29th, 2022. Do you understand the facts? Do you understand the rights that I just read to you?
Yes, ma'am.
Do you have any objection to me conducting this by video today?
No.
And can your attorney assist you by video? I mean, yes, by video.
Yeah.
All right, thank you. Ms. Tortorella, this is your case as well?
Yes, Your Honor.
Okay, and the state's recommendation?
A $2,000 surety bond, though we will not be opposed to a signature bond. The conditions is that she have no contact with the victim, Stanley Bryant, I believe his name is Stanley Turner. That's STANLEY, Turner traditional spelling. That she stay away from 10795 Morton's Crossing in Johns Creek. No weapons, no drugs or alcohol, and no new violations of Georgia law while she's out on bond. Your Honor, in this case, both parties got into a verbal dispute, and that dispute led to the defendant, Stephanie Arp, damaging property at the home. An officer, R. DeRucci of the Johns Creek Police Department, was dispatched on March 29th, 2022 to the incident location at 10795 Morton's Crossing in Johns Creek. Upon arrival, the officer spoke to the defendant, who stated that she was in a verbal dispute with victim Stanley Turner, which led to the damages in the home. The defendant advised that the officer that she was in a relationship with Mr. Turner in the past, and that she has been living with him since December 2021. When the officer spoke to Mr. Turner, he advised that he and the defendant both live in the residence and each have their separate bedrooms. The victim said that he and the defendant got into an argument which led to the defendant kicking the wall, causing a hole in the wall. And the victim then went up to his room and locked it. And the defendant then kicked his bedroom door, causing a crack in the door frame. The officer took photographs of the damages, and the defendant did admit to the officer to kicking the door. And all these events did occur in Fulton County, Georgia. Your Honor, we have had contact with the victim. He states that he and the defendant are not in a relationship and that they share no children. The victim stated that he is allowing the defendant to stay with him. He was allowing the defendant to stay with him to help her get back on her feet. The victim stated that he does not want any contact with the defendant and is seeking a TPO. The victim would like a one-time law enforcement escort for the defendant to retrieve her belongings. And he advised us that he was not going to be on the Zoom. So and there's nothing further from the state, Your Honor.
All right. Even though he's advised, let me sound for him now. Mr. Turner, if you are present on this Zoom conference and would like to make a statement, this is your opportunity to do so. I'm sounding for Stanley Turner at this time. All right, hearing none. Who represents Ms. Arp? I did not clarify that. Is it you, Ms. Gant? Or is it Ms. McLeod? Who represents? Oh, it's you, Ms. McLeod. Ms. McLeod, we can't hear you. You're muted. Or it looks like you may not have joined the audio. No, we can't hear you.
Can you still not hear me?
Oh, I can hear you now. There you are, Ms. McLeod.
Yes.
Okay, I've sounded for Mr. Turner. Is Ms. McLeod, what is the defense's recommendation for her bond?
Your Honor, we believe that she's qualified for a signature bond.
Okay. And your thoughts regarding the stay away and the no further contact with the victim?
She's okay with the stay away, Your Honor. It is her home.
Okay. All right. At this time, Ms. Arp is going to receive a $3,000 signature bond through pretrial services. She is to have no further contact with the victim, last name Turner. She must stay away from that address or Morton's Crossing. She can return one time with a member of law enforcement to retrieve any items, and she is to have no weapons, drugs, or alcohol as a condition of this bond.
I'm sorry, Your Honor, I misspoke. I said it was her home. It is not her home. She tells me that she has somewhere else that she can live. She can live with her mom, but she does have her cat and her phone at that location, and she needs to go back there to get them.
Right. I've ordered that she can go one time with law enforcement to get those items, Ms. McLeod.
Thank you, Your Honor.
All right. Is there anything further from either party? All right.
No, Your
Hearing
Honor.
none. Best of luck to you, Ms. Arp. We can move to the next position.
Position number 3, Ms. Clark.
All right. Good afternoon, Ms. Clark. I'm Judge Melanie Williams. Your case is 22 CR 0018003C, and you're charged with one count of theft by taking with an offense date of March the 29th of 2022. I've advised you of your constitutional rights. Do you understand them?
Yeah.
Can I conduct this hearing by video today?
Yeah.
And can your attorney assist you by video?
Yeah.
All right, thank you, Mr. Howard. Okay, is this first arrest, Mr. Howard? No.
07. Last arrest was 2014, suspended license.
Okay. All right, any other theft related charges in her history at all?
She had a theft by taking NOLO, but that was 1999.
Okay. That's good. All right, Ms. Tortorella.
Yes, Your Honor. We're recommending a $2,500 surety bond. The conditions is that she stay away from Plato's Closet at 10506 Alpharetta Highway in Roswell, that she take a theft class and no weapons and no drugs or alcohol and no new violations of Georgia law while she's out on bond. Your Honor, the defendant is currently being considered as a suspect for another theft incident that occurred on March 25th, 2022, and it involves the same victim, Plato's Closet. On March 29, 2022, an officer Gordon of the Roswell Police Department was dispatched to Plato's Closet at 10506 Alpharetta Highway in Roswell involving a theft in progress call. Through the officer's investigation, he was able to determine that the defendant, Amanda Clark, did take 2 bags full of clothes and shoes from the store's donation bin. The owner, Jessica Johnson, who was at the scene, advised the officers that the defendant resembles a white female who committed a theft at her store on March 25th, 2022, around 4 a.m. The officer was provided video of the incident and determined that the female in the video closely resembled the defendant. The female can be seen in the back of the business taking bags of clothes from the store's donation bin and loads the items on the back of the yellow Jeep Wrangler and leaves the scene. The defendant admitted to the officer that she drives a yellow Jeep Wrangler. The victim advised that the items stolen have an estimated amount of $5,000. All these events did occur in Fulton County, Georgia. Your Honor, the defendant has 7 cycles. She was convicted for theft by shoplifting on March 27, 2000 from Gwinnett County State Court. She was arrested, like you've heard, from pretrial and back in 1999 for theft by taking, where she did plead nolo. On March 16, 2001, she had a violation of probation out of Gwinnett County. And on September 15, 2000, she had a violation of probation out of Gwinnett County as well. Your Honor, the state has concerns that she poses a risk of reoffending. She has a criminal record with 7 cycles, and though it may seem remote, she is before us with a new offense and currently under investigation for another, Your Honor. So for this reason, we do feel that a $2,500 surety bond for this matter is more than justifiable. Nothing further.
All right, thank you. And is it Ms. Gant? Ms. Gant, what is the defense's recommendation?
Yes, Your Honor, thank you. We are requesting a signature bond. She is recommended, and we would be willing to even take a signature bond through the jail. We are unopposed to the stay away. We are also opposed to the theft class. We heard my client's history. However, I believe that it is too remote to consider. And regarding the ongoing investigation, I would ask that Your Honor just consider the charge that are within the charge that is before the court today. Ms. Clark is 41 years old. She has been in the Atlanta area since age 16. She has a 16-year-old daughter. She also has other family here, including her mother, sisters, and brothers. Therefore, she has community ties. She completed high school. She also reached junior status in college, where she studied general studies. She has been unemployed since December 2020 because of an accident. She's recovering. She states that she was injured during a motor vehicle accident when an 18-wheeler collided with her. She has undergone several operations. Again, Your Honor, I am requesting, in light of my client's remote history for theft, that a signature bond or the lowest bond possible. Again, we're unopposed to the stay away and the theft class. Thank you.
To clarify, Ms. Gant, you said you are unopposed to the theft class, or you are opposed to the theft class?
Opposed to the theft class.
Okay, then I wanted to clarify that. All right, thank you. At this time, Ms. Clark is going to receive a $5,000 signature bond through pretrial services. She is to stay away from that Plato's Closet location, and she is to have no weapons, drugs, or alcohol as a condition of this bond. Are there any questions or comments from either party before we go to the next case?
Nothing further, Your Honor.
All right, hearing none. We can go to the next case.
Position number 6 in courtroom 3. Miss
All right. Dundero, correct?
Dundero.
Are you Leah Dundero? All right, Ms. Dundero, your case is 22 CR 001807F, in which you're charged with 3 counts of disorderly conduct with an offense date of March the 14th. Do you understand your constitutional rights? Do you object to me doing a video hearing for you today? And can your attorney assist you by video?
Yes.
Thank you. Thank you. Mr. Howard, of second arrest, what was it? Will you put on the record what it was, Ms. Howard?
2019 suspended license. Dismissed. She got pre-trial and felony first appearance earlier.
Okay. Thank you. Ms. Tortorello?
Yes, Your Honor. And just to add, the victims are on the Zoom court today. Your Honor, for each disorderly conduct charge, the state's recommending a $500 surety bond, which would be a total of $1,500. The conditions is that she have no contact with the victims, Kimberly Fletcher, traditional spelling, Ashley Yates, the last name is Yates, and Sabrina Harrison, traditional spelling. 1 day anger management, no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, in this case, the defendant, Leon Dondero, repeatedly went inside the Sovereign Women's Healthcare at 1875 Old Alabama Road in Roswell and yelled expletives at the victims involved in the case and in front of their patients. So, Your Honor, on March 14, 2022, an Officer G of the Roswell Police Department responded to Sovereign Women's Healthcare in Roswell in reference to a belligerent patient. Upon arrival, the officer spoke to victim Kimberly Fletcher, who advised that the defendant arrived at the incident location around 9 a.m. and was agitated about completing a new patient paperwork and having to wait outside. The victim stated that the defendant repeatedly came into the office and kept yelling and calling them, and I quote, cunts and bitches, end quote, to her and her staff and in front of the patients. The victim stated she went to consult with the other victim, Dr. Sabrina Harrison, about the matter. And when Dr. Harrison came to the front to speak to the defendant stormed into the building and once more continued to yell expletives and use the same language she did before. The victim, Ashley Yates, who was a patient at the incident location, stated she was in one of the patient rooms and heard the defendant storm in yelling expletives and feared for her safety and did not come out of the room. She feared the defendant would enter her room. Ms. Yates advised the officer she recognized the defendant as a woman standing outside. And all these events did occur in Fulton County, Georgia. Your Honor, we have concerns of as far as intimidating witnesses. Though this is a disorderly conduct, charges are involved. Her actions were violent in nature, and the state has concern she poses a risk to the victims as she knows where they work and where one of them is a patient at. To add the concern of public safety, Your Honor, she did commit these acts in front of the general public. She also poses a risk of reoffending. The defendant has an open felony case for possession of scheduled drug substance and a theft by shoplifting. It's 22 CP 207890. And the incident date was yesterday, Your Honor, March 29, 2022. This shows she is likely to reoffend as her felony incident occurred after this current case. And not only is she likely to commit offenses, Your Honor, she's likely also to commit felonies while out on bond. Nothing further from the state.
I'm sorry, I did not catch the stay away address, Ms. Tortorella. What was the stay away address? Was the state requesting a stay away?
We could do a stay away, Your Honor. I'll add that. It's 1875 Old Alabama Road in Roswell, Georgia.
Okay, thank you.
Yes, Your Honor.
Before I go to you, Ms. Gant, I am going to sound for the victims. With victim last name Fletcher. If you would like to make a statement, this is your opportunity to do so. Ms. Fletcher, if you would like to make a statement, I will need you to turn on your camera. You are not required to make a statement, but this is your opportunity to do so. All right, hearing none, I will go to Ms. Yates. Ms. Yates, if you are present on this Zoom conference and would like to make a statement, this is your opportunity to do so. I would just need you to turn on your camera. Ms. Yates, if you would like to make a statement, this is your opportunity. All right, hearing none, I'm now sounding for Dr. Sabrina Harrison. Dr. Harrison, if you would like to make a statement, this is your opportunity to do so. You are not required to, however, but if you would like to, I would need you to unmute and turn on your camera if you have. Oh, is that you? Is that you, Ms. Dr. Harrison? Yes, this is Sabrina. Would you like to make a statement? You're not required to.
I just want something to be done.
Before you speak, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth under the penalty of perjury?
Yes.
Okay, thank you. You can put your hand down. What would you like to tell me today?
I just want something to be done. I don't know if she needs what she needs, but what she did is scare my patients. It scared new patients that were in the office. And it scared my staff was extremely nervous about their safety with her and with me even just going to get her tag number or going to talk to her reasonably. And there's still a concern.
Thank you, Dr. Harrison. I appreciate you making a statement today.
Thank you.
Ms. Gant?
Thank you, Your Honor. Miss Leah Dundero is 32 years old. She has been in the Atlanta area for over 20 years. She has family here, including her 2 children, ages 8 and 4. She is the primary caretaker and she is not receiving any child support. We are unopposed to the stay away at 1875 Old Alabama Road. We are also unopposed to the no contact orders, as Ms. Dundero is not an established patient there and has no need to return. Ms. Dundero completed high school. She has some college credits in the area of psychology. She is unemployed at this time. Therefore, Your Honor, she is unable to pay anything toward bond. She states that she was scheduled for a job interview today. I am requesting a signature bond on Ms. Dundero's behalf. We heard about her criminal history, which is for driving or traffic offense back in 2019. We have not heard about any convictions for violence whatsoever, and she is presumed innocent in this case. She disputes the allegations, Your Honor. She states that the staff there were rude to her and that she walked away. We believe that the stay away orders and the no contact orders will take care of any concerns regarding the state for intimidating witnesses. And again, for these reasons, Your Honor, I'm requesting a signature bond on Ms. Dundero's behalf. Thank you.
Thank you, Ms. Gant. At this time, I'm going to accept the state's recommendation. Ms. Dundero is going to receive a $1,500 surety bond, $500 surety for each count. She is to have no further contact with any of the victims, last name Fletcher, Yates, or Harrison, and she is to stay away from the address at 1875 Old Alabama. She is to have no weapons, drugs, or alcohol as a condition of this bond.
Thank you, Your Honor.
Is there anything further from either party? All right, if not, best of luck to you, Ms. Dundero. Who do we have next?
Position number 14, Ms. Johnson.
Good afternoon. Please pronounce your first name for me.
Shaquanla.
You are Shaquanla Johnson?
Yes.
Ms. Johnson, your case is 22 CR 001817G. I'm Judge Melanie Williams. You are charged with 1 count of simple assault and 1 count of driving hit and run, duty to stop and return to the scene of an accident with an offense date of March the 7th of 2022. Do you understand your constitutional rights?
Yes.
Can I conduct this hearing by video today?
Yes.
Can your attorney assist you by video?
Yes.
Thank you. Mr. Howard.
Second arrest. Last arrest was back in November. Criminal trespass, damage to property. That's a pretrial bond.
Okay. All right, thank you. Whose case is this for the state? Is you, Ms. Mitchell?
Yes, Your Honor.
And the state's recommendation.
The state's recommendation is going to be as to count 1, a $2,000 surety bond, count 2, $2,000 surety bond, totaling a $4,000 surety bond. No further contact with the victim, Ms. Shenitra, spelled Senetra, Gates, common spelling. A 1-day anger awareness course, and no alcohol, drugs, and weapons. Your Honor, in this case, the defendant was involved in a car accident at the intersection of Myrtle Street and Grove Way in Roswell, Georgia, and failed to remain at the scene to provide her information. The defendant then assaulted Ms. Gates by exiting her vehicle with a baseball bat and stated that she will, quote, beat her ass. The defendant proceeded to follow Ms. Gates, cut her off with her vehicle, and exited a second time, still while holding the baseball bat, and continued to make threats about beating Ms. Gates up. Your Honor, our victim advocate had an opportunity to speak with Ms. Gates, and she stated that she does not know the defendant, but that they live in the same neighborhood. The defendant lives 3 doors down from her. She also stated that she's never seen the defendant before this incident, and that while she was driving, the defendant came up from behind her and cut in front of her, and that's how their cars impacted. The victim also stated that the defendant immediately jumped out of the car with the bat and stated that she will beat her ass. So she confirmed what was in the warrant. The victim was adamant about no contact with the defendant. So that's going to be the basis of our recommendation. Nothing further.
Thank you. I appreciate that. Ms. Whitfield.
Yes, thank you, Your Honor. We are going to be asking for a signature bond for Ms. Johnson in light of her relative lack of criminal history, Your Honor. She has not yet been convicted on that criminal trespassing case. She denies these allegations, Your Honor. She actually had her child in the car with her. She denies that she would have been driving that way, would have had a collision. She does not know Ms. Gates, but believes this may have been an issue between some other neighbors in the area who might have made these allegations up against her. She has been in Atlanta all her life. She is a high school graduate and is currently working for sort of app delivery like Instacart, Uber Eats, that's those sort of apps. Like I said, she does not know Ms. Gates. She does not oppose a no contact with her. And as far as the incident location, 200 Grove Place, that's just a random address where the accident is alleged to have occurred. We would not ask for a stay away because she has to drive through that address to leave her neighborhood, Your Honor. So like I said, Your Honor, at this point, we'd be asking for a signature bond given her lack of criminal history and she wants to return to court to fight this. There could be an identity issue as well, given that she was not present when this alleged accident took place. She was not given a chance to speak with law enforcement.
All right, thank you. At this time, Ms. Johnson is going to receive a $1,500 surety bond. It'll be $1,000 for count 1, $500 for count 2. She is to have no further contact with the victim, last name Gates, and she is to have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further from either party?
Nothing further, Your Honor.
All right, best of luck to you, Ms. Johnson. We can move to the next position.
Position number 18.
Oh, you still on.
I'm sorry, which one? Where are we going?
18, Your Honor.
Okay. All right, are you Sabra or Sabra? Pronounce your first name for me.
Sabra.
Sabra Stevenson. Ms. Stevenson, your case is 22 CR 001819Y. And what you're charged with, one count of battery family violence with an offense date of December the 30th of 2021. Do you understand your constitutional rights?
Yes.
Do you object to me conducting this hearing by video?
No.
And can your attorney assist you by video?
Yes.
Ms. Howard, first arrest?
No.
Okay.
Fifth arrest. Last arrest was back in May 2021 for DUI. 2013 ag assault. It was amended to battery and then dismissed. Ag battery, ag assault dismissed from 2009, and a 2009 simple battery DV arrest. That's it.
Okay. Thank you. Ms. Mitchell?
Yes, Your Honor, the state's recommendation is going to be a $5,000 surety bond, no further contact with the victim, Mr. Renard, spelled R-O-N-A-R-D, Bird, spelled B-Y-R-D, a stay away from the address 640 Garibaldi, spelled G-A-R-I-B-A-L-D-I, Street, Southwest, Atlanta, Georgia, a one-day anger awareness course, and no alcohol, drugs, and weapons. Your Honor, in this case, on December 30th of last year, the defendant battered her live-in boyfriend, Mr. Bird, by striking him in the head while holding a set of keys, causing a laceration on his forehead. It started with an argument in their car that continued when they arrived to the residence on the front porch. Mr. Bird's two children were present during the incident. His 12-year-old daughter got between the two, attempting to keep them apart. That's when the defendant struck Mr. Bird with keys in hand, leaving a gash on his forehead. The defendant then started attacking Mr. Bird's daughter by pulling her hair, pulling multiple braids. The defendant then started running around the house, dialing 911, saying that Mr. Bird was attacking her while Mr. Bird was just trying to get the defendant to let go of his daughter. That's when Mr. Bird's son then stepped in so that the defendant would let go of his sister, and the defendant then turned and hit him in the face. So based on those allegations, the nature of those facts, and the history, although she does not have a conviction, it is showing a violent pattern between the aggravated assault and amended to a battery in 2014, aggravated battery, aggravated assault 2009, and simple battery family violence in 2009. We are recommending the $5,000 surety bond. And the defendant's DUI case from last year appears to be open as well. Nothing further, Your Honor.
All right, at this time, I'm going to sound for the victim, last name Bird. Mr. Bird, if you are present on this conference and would like to make a statement, this is your opportunity to do so, even though you are not required to do so. All right, hearing none. And Ms. McLeod, is this your client?
It is, Your Honor.
All right.
My
and
client
the defense-
denies that that was what happened. She said what happened was that the children are fighting and they were trying to separate them when this happened. Your Honor, we are opposed to any kind of stay away order from this location because it is my client's home and Mr. Bird's name is not on the list. She tells me that they have been living together for the past 2 years. Although they have no children together, they were raising 5 children, a total of 5 children, 3 of whom are hers and 2 of whom are his. But she has told me that based on all of this, she considers the relationship to be over now. I'd like to point out, Your Honor, that the only thing she has outstanding is that DUI, and she is presumed innocent in that because she has not been found guilty, nor has she pled guilty to that. Also, the court should note that even though she was charged previously with aggravated assault, that was reduced to simple battery and dismissed. She was not convicted of that. Therefore, I think, Your Honor, she's a good candidate for signature bond. She does live in the Atlanta area. She works in Fulton County and has been doing so for some time, Your Honor, and has no criminal history really, because to say that someone was charged, she definitely was not found guilty in anything at all. Therefore, I still think she's a good candidate for a signature bond, Your Honor. And she does have 3 children that she needs to get home and take care of, and also to get back to her job.
Ms. McLeod, is it your contention? You saying their relationship is over? Are you contending that the victim no longer lives at that address?
I'm contending that their relationship is over, Your Honor. That's what she has told me. And
Okay.
he was living with her, but it's her name on the lease. It is her home. And she had
Right,
lived there before
that.
with her children.
I understand that part. I'm trying to clarify. Ms. Mitchell, the address that you have for the victim is that he still currently resides at that address?
As far as we know, Your Honor, his number wasn't in service when our victim advocate tried to get in contact with him.
All right, here's what I'm gonna do. Ms. Stevenson is gonna receive a $5,000 signature bond through pretrial services. She is to have no further contact with the victim, last name Bird. She is to complete the 1-day anger awareness course. She is to stay away from that address on Garibaldi Street so long as the victim does not live there. I mean, as long as the victim lives there. If the victim is there, she cannot reside at that address. She can return one time with a member of law enforcement to determine whether or not the victim resides there. And if he does, she will need to stay away from that address, but she can collect any items she may have. If the victim is not there, she can return to her home. All right, is there any questions regarding that ruling?
Yes, Your Honor. The thing is, she's the one responsible for the lease, responsible for the payments. So if the alleged victim is going to be there, she would have to be paying for somewhere else while still being responsible for paying for that lease.
I understand, Ms. McLeod, but so long as the victim's there, I don't have the jurisdiction or authority to order the victim to leave that property at this time. So she'll need to work through that, and hopefully if the relationship has ended, he will voluntarily leave. If the victim makes a statement that he's gone or there's evidence that he no longer lives there, then the stay away will not be in effect, but she can't be there for as long as he resides at that address. All right.
Thank you.
Is that a 5,000 SOB or surety bond?
It's SOB through pretrial services. All right, is there anything further?
No, Your Honor.
All right, hearing none. Best of luck to you, Ms. Stevenson. Who do we have next?
Thank you.
Position 7, Mr. Fernandez.
All right, good afternoon. Your case is 22 CR 001809Y, in which you're charged with criminal trespass. Do you understand your constitutional rights?
Yes, ma'am.
Do you object to the video hearing? Can I do this by video today?
Yes, ma'am.
And can your attorney help you by video?
Yes.
Thank you. Mr. Howard.
25 total.
Yeah.
Last arrest was back in November for shoplifting, possession of drug-related objects in the cab. In October 2019, he was given 3 years probation in Gwinnett for possession of meth. September 2021, shoplifting arrest. August 2021, shoplifting arrest. July 2021, simple battery obstruction, criminal trespass. June 2021, possession of a Schedule 1 controlled substance. 2020 probation violation. 2019 probation violation.
Okay, I think I've got it. That's good, Ms. Howard. Thank you. Ms. Tortorella?
Yes, Your Honor. The state's recommending a $1,000 surety bond. The conditions is that he stay away from the Quick Trip at 761 Sidney Marcus Boulevard. Sidney is spelled S-I-D as in dog, N-E-Y. Marcus Boulevard Northeast in Atlanta. No weapons, no drugs or alcohol, and no new violations of Georgia law while the defendant is out on bond. Your Honor, in this case, Officer Gray of the Atlanta Police Department was flagged down by a security officer named John Hammond of Quick Trip. This occurred on March 29th, 2022 at 761 Sidney Marcus Boulevard. The security officer informed Officer Gray that the defendant, Elise Fernandez, had been issued a criminal trespass warning prior to the incident date. The officer detained the defendant, who identified himself to the officer. The officer looked up the defendant's name and saw that he was in fact arrested in the past for criminal trespass at the same location. And all these events did occur in Fulton County, Georgia. Your Honor, the defendant has he pled NOLO in Fulton County State Court for simple battery on July 23rd, 2021. As you heard from pretrial, he has several recent arrests which indicate that these cases may still be open. A February 5th, 2022 criminal trespass arrest out of Lilburn. A November 13th, 2021 theft by shoplifting, possession of firearm or knife during a commission of a felony out of DeKalb County, and it's the DA's office, Your Honor, and it appears to still be open. And a September 21st, 2021 theft by shoplifting arrest out of Gwinnett County. Your Honor, we do have concerns that he poses a risk of reoffending. He has about 4 open possible cases, and this could infer that this defendant will likely reoffend while out on bond and also possibly commit felonies given his record, Your Honor. And for this reason, we do feel that a $1,000 surety bond is more than reasonable, Your Honor, for this matter. Nothing further.
All right, thank you, Ms. Gant.
Thank you, Your Honor. Mr. Elise Fernandez is 25 years old. He has been in the Atlanta area for 2 years. He does have family here, therefore he has community ties. We are unopposed to the stay away at 761 Sidney Marcus Boulevard. Mr. Fernandez completed the 11th grade. He has been unemployed since 2021. He states that he was about to start a new position at Waffle House. He does not have the means to pay any bond. Your Honor, he disputes the allegations. I am requesting a signature bond on Mr. Fernandez's behalf. He does not have the means whatsoever to pay any bond, nor is his family able to help him. Your Honor, we heard the state state that Mr. Fernandez likely has possible cases and he is possibly at risk of reoffending. Well, Your Honor, he hasn't been convicted, and if by chance those cases are open, he is presumed innocent. For these reasons, Your Honor, I am requesting again a signature bond, and again, we're unopposed to the stay away. Thank you.
Okay, my question was, he was just at the gas station, is the contention, Ms. Tortorella, even though he was previously told not to be there?
Yes, Your Honor, it's an regular trespass charge.
Okay, just wanted to be clear. All right, at this time, the defendant is going to receive a $2,000 signature bond through the jail. He must stay away from the address on Sidney Marcus Boulevard. He is to have no weapons, drugs, or alcohol. Sir, I am giving you a signature bond at this time, but you can absolutely not return to that location. Do you understand that?
I'm not here, sir. Yes,
You
ma'am.
understand that? You cannot return to that location?
Yes, ma'am.
All right, they don't want you back there. Do not go back there, all right? Best of luck to you. Who do we have next?
And Your Honor,
Yes.
if I may, I
I'm
am also requesting social worker services to help him with his housing resources as well.
Okay, thank you, Ms. Gant. We appreciate that as well. Please make sure that's done.
Thank
And you have good contact information for your client as well, Ms. Gant? You're muted. You muted yourself.
I do not, Your Honor, and I am calling Miss Min Williams now to connect with him.
Okay, thank you.
You're welcome.
All right, who do we have next?
Position 12, Mr. Honeycutt.
Your Honor, this defendant has two open cases.
Right. Oh, is this 11? We're doing 11 and 12. Latrell Honeycutt. Is that you, sir?
Yes, ma'am.
Okay, you have two cases. The first case is 22 CR 001831J, and you're charged with 2 counts of battery family violence in that particular case, one with the offense date of March the 25th and one with the offense date of March the 28th. Your second case, you're charged with battery and simple battery against a person who was pregnant at the time of the offense and discharging a firearm with an offense date of December the 13th of 2021. Do you understand your constitutional rights?
Yes, ma'am.
Can I conduct this hearing by video today?
Yes.
And can your attorney help you by video?
Yes.
Okay, I thank you for that. Mr. Howard?
18 total. Last arrest was 2018. Failure to appear for entering auto, burglary, 2nd degree, possession of tools for the commission of a crime, criminal damage to property, 2nd degree, 2018 probation violation for those same charges, 2017 failure to appear for those same charges, another 2017 probation violation, criminal attempt to commit a felony, contributing to delinquency of a minor, criminal trespass convictions from 2016, 2016 probation violation. Underlying charge was burglary. He got bench warrants as well for those
Okay.
charges I just named.
Okay, thank you. Ms. Tortorella?
Yes, Your Honor. I just wanted your direction as far as how you'd like me to do this. Do you want me to just go over the facts first and then the bond recommendations for each case, or?
Yes, I'd like to try to do them at once if we can. So if you give me the facts of position 11 and then your recommendation for bond and go straight into position 12, that would be ideal.
Okay, Your Honor. So for position 11, he's charged with 2 counts of battery family violence. And just to clarify the record, the incident date did occur on March 28th, 2022 for both counts.
Okay.
So on March 28th, 2022 at 2:31 a.m., an Officer Hargrove was dispatched to 3029 Dobbs Way in East Point, Fulton County, Georgia. Upon arrival, the officer spoke to Ms. Sharonica Lewis, the victim. Ms. Lewis stated that when she returned to her home at 1347 East Washington Avenue in East Point, Georgia, her boyfriend, Latrell Honeycutt Jr., advised he wanted to talk. Then Lewis stated shortly after the conversation, the defendant snapped and started hitting her in the face with a closed fist. Ms. Lewis stated that the defendant continued to hit her in the face and kicked her in the stomach for about an hour, Your Honor. Ms. Lewis stated that she began to vomit from Mr. Honeycutt kicking her in the stomach. Ms. Lewis stated that Honeycutt Jr. followed her around the house, beating her in her head, arms, legs, back, and hands, and all this in front of her grade school age son, Your Honor. The victim did have to go to Grady due to her injuries that she sustained. And for this offense, Your Honor, the state is recommending for the first count of battery family violence, $10,000 surety bond, and the second count of battery family violence, another $10,000 surety bond. It's our understanding that the victim and the defendant at the time lived together. So the total surety would be $20,000 surety, that he have absolutely no contact with Ms. Sharonica Lewis, and her name is spelled Sharonica, and the last name is Lewis for the record, to stay away from her location at 1991 Delowe, and that's DELOWE Place, apartment 07 in Atlanta. 1 day anger management, that he relinquished his handgun, Your Honor, and no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, now for the simple
One
battery.
question,
Yes,
Ms.
Your Honor.
Tortorella, before you go to the next case, so the stay away is, you're requesting to stay away from the Delowe Drive address, not the Dobbs Way, correct?
It's 1991.
Delowe Place, that's the requested stay away address for position 11?
I'm sorry, Your Honor, I got these confused. For Ms. Sharonica Lewis's address, it's 1347 East Washington Avenue, apartment B in East Point.
Okay, so that's the stay away address that goes with position 11. I'm presuming that the other address will go with position 12?
That's correct,
Okay.
Your Honor.
All right, go ahead and go into position 12.
Yes, Your Honor. So this case involves acts of violence by defendant, which include firing shots in the air in front of a child and a pregnant victim, Andrea Powell, throwing a cell phone which hit the 9-year-old juvenile victim, ZP initials, and striking a pregnant woman, again, victim Andrea Powell. On December 13, 2021, Officer D. Matthews of the Atlanta Police Department was dispatched to the incident location at 1991 Delowe Drive. Upon making contact with the victim, Andrea Powell, the officer noticed the victim to be hysterical and scared. Victim advised the officer the defendant, Latrell Honeycutt, came to her residence on drugs, and she advised the defendant to leave. The defendant refused to leave and advised the victim about how he wanted to be with her. The victim advised she told the defendant she did not want to be with him and that he needed to leave so she could put her kids to sleep. The victim said the defendant became angry, and so she went to her sister's house for protection. As she was attempting to leave, the victim said the defendant slapped her and took her cell phone. The victim said she asked for her phone back, and the defendant then threw the cell phone at her, which bypassed her and instead hit her 9-year-old daughter, initials Z as in zebra, P as in Peter, in the arm. This act by the defendant caused the child to have bruises on her left arm. The victim said that before the defendant left the scene, he took out a black gun and pointed it up in the air and fired 2 shots. The victim said he did this to scare her, and then he drove off in an unknown car at a high rate of speed. The victim also showed the officer text messages from the defendant threatening to cause harm to her. The victim stated that she is pregnant with the defendant's child. The officer found two casings in the area, and all these events did occur in Fulton County, Georgia. Your Honor, defendant is a convicted felon based on his record, and therefore we will be transferring this to DA's office due to him possessing a firearm, giving the facts of this case. The defendant has also an open aggravated assault case with the offense date of November 14th, 2021. That's 22 SC 181187. And he has 3 counts of aggravated assault with a deadly weapon and 1 count of simple battery family violence. It involves the victim's sister in this case, Ms. Christina Powell, where he pointed a gun at her. Your Honor, this defendant also has convictions, felony convictions, possession of MDMA, convicted on February 1st, 2018 in Fulton County Superior Court, criminal attempt to commit felony, convicted on February 9th, 2017 in Clayton County Superior Court, a burglary conviction out of Fulton County Superior Court. This was May 14th, 2016. He has a couple of FTAs Your Honor, on his record, one in 2018 and one in 2017 out of Fulton County, which are the most recent that I've seen, Your Honor. But Your Honor, we do have concerns again, and we feel like a $20,000 surety bond for this case and the case involving Miss Lewis is more than justifiable, Your Honor. And we do have the victim, Miss Veronica Lewis, on the Zoom, Your Honor. Nothing further from the state.
All right, I'm sorry, Ms. Tortorello. Can you please give me the breakdown again for position 12 as requested by the state? I got the stay away and the victim's name.
Yes.
What was the request of the breakdown?
Yes, position 12 is the battery and the simple battery, Your Honor.
Yes.
So it'll be no contact with victim, the juvenile victim, ZV, the initials, and Andrea Powell. And the last name is spelled Powell, to stay away from the incident location at 1991 Delowe Drive, and that's spelled DELOWE Drive Southwest. That's apartment 07 in Atlanta, Georgia. That he take a one-day anger management class, that he also relinquish his handgun, and no weapons, no drugs or alcohol, and no new violations of Georgia law.
And the monetary breakdown, because I have, there's also the discharge of the firearm. So what was the amount requested by the state for that?
Yes, Your Honor. For the battery, a $10,000 surety bond. For the simple battery on a pregnant female, it's a $5,000 surety bond. And for the discharge of firearm is a $5,000 surety bond.
Okay, that was one I missed. All right, thank you so much, 5,000 there. All right, at this time, I am going to sound for the victim, last name Lewis first. Ms. Lewis, if you are present on the Zoom conference and you'd like to make a statement, you are not required to do so. Would you like to make a statement, Ms. Lewis?
Yes.
Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth under the penalty of perjury?
Yes.
Okay, you can put your hand down. Do you wish to have contact with Mr. Honeycutt?
I do not.
All right, is there anything else you'd like to tell the court?
Obviously he's going around the city beating up women, and that's not okay. That's not okay. You really, really hurt me. Like, I could have died in front of my child, and he didn't care. He didn't care. He didn't care. I could have died, almost died in front of my child, and you didn't care.
All right. Thank you, Ms. Lewis, for making that statement. I appreciate you coming to court today. All right. At this time, I'm going to sound for the victim, last name Powell. Ms. Powell, if you are present on the Zoom conference, this is your opportunity to speak. Again, you are not required to do so. Ms. Powell, if you do want to speak, I would just need you to turn on your camera at this time. All right, hearing none, we'll go straight to you, Ms. Whitfield. If you'd address it the same way, if you'd first speak about position number 11, then go straight in position 12, that'd be ideal.
Yes, thank you, Your Honor. It's actually sort of the same argument for both cases, Your Honor. He denies the allegations. Of course, he believes that he has, Mr. Honeycutt believes that he has been put in a bad situation by people who want to take advantage of him, Your Honor. So as far as the first case goes, for Bond, he does not oppose a stay away or no contact provision with Ms. Lewis, Your Honor. He did not live at that address at Washington Avenue, and he actually lives on another address, so he does not oppose that. We would be, and if I could go into a little bit of his situation, Your Honor, he does not live with either Ms. Lewis or Ms. Powell in the second case. He was previously in drug court for for some prior charges, Your Honor. He had been doing well, but unfortunately, because he was rearrested on some other offenses, he lost his job. He had been doing construction work through a temporary agency before that, and he just he was unable to pay and unable to continue that. He does have one stepchild, Your Honor. He's and another one on the way, Miss Powell. I believe she is due to give birth any day. He's 28 years old. He has lived in Atlanta his whole life. He does have extended family members and community ties here. His mother is listed as an emergency contact here, Your Honor. And with regards to the first case, if we could request, or aware of his history and the fact that he has 2 cases, Your Honor, we'd be asking for no more than $4,000 good bond on these charges, $2,000 per charge. And he does not oppose a stay away or no contact provision with Ms. Lewis. In terms of the second case, Your Honor, we would request no more than $5,000 good bond per total, I would say, splitting it however Your Honor would like to split it. He does request that he have third-party custody transfer of children of Ms. Powell's, the child he and Ms. Powell are about to have together, Your Honor. I believe she's due any day now. So once that child is born, he will of course have custodial rights to that child and would request a third-party transfer.
You're requesting a third-party transfer of a child that's not yet born, Ms. Whitfield?
Yes, but I don't know when the child will be born. I just know that it is going to be any day now. So whenever that child is born, if that could kick into effect. I'm not sure how to request that other than, or what other legal mechanism I could.
I understand. I appreciate.
Yeah, I just want to make sure his custodial rights are protected.
All right. All right, at this time, I'm ready to rule on position 11. Mr. Honeycutt is going to receive a $15,000 surety bond, $7,500 for each charge. He is to have no further contact with the victim, last name Lewis, and he must stay away from that address on East Washington Avenue. And he is to have no weapons, drugs, or alcohol. Should he have a handgun, he needs to surrender that. Position 12, it's going to be, I'm so terrible at math. It's going to be a $7,500 surety bond. That's $2,500 on each count. I believe there are 3. He is to have no contact with the victim, last name Powell, and stay away from that address on Delow Drive. Again, he must surrender any weapons and have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further from either party?
Nothing further, Your Honor.
No, Your Honor.
All right. All right, best of luck to you, sir. We're going to move to the next position.
Position 16, Mr. Roberts.
All right, good afternoon. Are you Robert Roberts?
Yes. Yes, ma'am.
Mr. Roberts, your case is 22 CR 001818E, in which you're charged with criminal trespass, family violence with an offense date of January the 10th of 2022. Do you understand your constitutional rights?
Yes.
Can I conduct this hearing by video?
Yes.
And can your attorney assist you by video?
Yes.
All right. Mr. Howard?
23 total. Hold on, George. Last arrest was on the 15th of this month for suspended license out of Lowndes County. Has history out of New Jersey. 2017, simple assault, criminal mischief, burglary. 2017, trespass conviction. Also has history out of New York. See a 2015 robbery. Criminal impersonation conviction from 2015 out of New York as well. 2018 arrest. Criminal mischief, intent to damage property. Another criminal mischief and harassment 2nd degree. Got another 2018 arrest for burglary 2nd degree. Criminal attempt violation of a protection order. 2018 false impersonation, possession of marijuana, unlawful, unlicensed operation of a motor vehicle. 2018 drug conviction. I think that's about it. We got a June 2021. Yeah, the damage to property and the harassment, 2nd degree.
All right, thank you, Mr. Howard. Ms. Mitchell.
Yes, Your Honor, the state's recommending a $2,500 surety bond. No further contact with the victims in this case, Miss Ashani, spelled Ashani, Ackerman, common spelling, and their daughter. So that means we're not at this time, we're not requesting the third-party transfer of their child. We're also asking for a stay away from the address 3380 Peachtree Road Northeast, Atlanta, Georgia, which is Ms. Ackerman's address, a one-day anger awareness course, and no alcohol, drugs, and weapons. Your Honor, in this case, the defendant damaged the front windshield of Ms. Ackerman's vehicle and the entry door of her apartment. The defendant and Ms. Ackerman do share a 5-year-old daughter. It started when the defendant came to drop something off for their child and he refused to leave. Ms. Ackerman went to her vehicle because she had to take their daughter to school and the defendant followed them. The defendant then jumped onto the hood of her vehicle and began punching the windshield, shattering it while Ms. Ackerman and their child were inside the vehicle. After the defendant got off of her car, Ms. Ackerman dropped her child off at school and returned home to her apartment. The defendant was still there and he started banging on the door of her apartment until he broke it and forced entry into her apartment while she was inside. Once inside, the defendant began trashing her apartment and took her car keys and diamond chain. As you've heard from pretrial, the defendant is a convicted felon and has an extensive history, most of which is in New York. He was convicted of 5 counts of felony drug charges in 2018 and 2 counts of contraband in 2019. It appears there's an outstanding warrant that was issued last year for failure to appear out of Florida. And then he does have the open case for damage to property and harassment in 2021 in New York. So it appears he's fleeing from that case at this time. We do have concerns of him being a flight risk and in addition to his risk of reoffending. Our victim advocate had an opportunity to speak with Ms. Ackerman and she states that she does not want contact with him and wants to stay away from her residence. The victim stated that the defendant has paid for the damage he caused to the car. And she states that this is not the first time the defendant has trespassed on her property. Due to the nature of the allegations, we are concerned, as far as the third-party transfer goes, we're concerned for the child, being that he broke and shattered the windshield while she was inside and was only 5 years old. So based on that, we are recommending a $2,500 surety bond, nothing further.
All right, thank you. Ms. Whitfield.
Yes, thank you, Your Honor. Mr. Roberts is 31 years old. He has been living in the Atlanta area for about 2 years. He is originally from New York. He has been a music producer for the past several years, about 4 or 5 years. He completed 2 years of college. He does have his associate's degree in psychology. He does share 1 child with Ms. Ackerman. They do not live together. Your Honor has heard that he did pay for the damage to her car already, so he has taken that responsibility, Your Honor. We do not oppose a no contact provision with Ms. Ackerman and to stay away from her address, Your Honor, especially in light of the fact they don't live together. However, we would still request third-party custody. He has not had his custody rights relinquished yet, and he still has a legal right to see his daughter, Your Honor. So we would also request that given Mr. Roberts' financial situation, which Your Honor is to consider, he has no more than about $100 that he, to his name, Your Honor. We'd request that Your Honor impose a bond of about $1,000, good bond. We're aware of his criminal history and prior allegations. However, given that he has already tried to make amends in this case and does not pose a risk of intimidating a witness with honoring a no contact provision in this case, I would ask for a $1,000 good bond.
All right, thank you. At this time, I'm going to sound for the victim, last name Ackerman. Ms. Ackerman, if you are present on the screen and would like to make a statement. this is your
I'm here.
Would you like to, if you would like to make a statement, Ms. Ackerman, you have to turn your camera on so it can identify you. You are not required to make a statement, however.
Hello.
All right, would you like to make a statement?
Yes.
Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
Yes.
All right, what would you like to tell the court today?
I was telling the DA that he did pay for the door and the windshield, and we do have a child in common. So I don't mind that he doesn't oppose as a threat to me. I haven't seen him in a while, but he does send my mom money for my child, as well as I don't mind him seeing her because he doesn't oppose as a threat to her as well. But the situation was a little out of hand. We were dealing with a few deaths in the family, so it was a lot of tension. But I don't really wish to proceed with charges, being that I did get my money back. So, I mean, that's just all I have to say.
Thank you. At this time, Mr. Roberts is going to receive $1,000 surety bond. He is to have no further contact with the victim, last name Ackerman, and he must stay away from that address. He is to have no weapons, drugs, or alcohol. I am not going to issue that there's a third-party transfer at this time. He's going to have no further contact with his daughter, but that can be modified at a later date. As he is receiving a surety bond, his case is also reset to the SAP calendar on April the 12th, whereby that can be revisited. But for now, it will be a no contact with both parties. Is there anything further from either? All right.
Thank you.
All right, best of luck to you. Who do we have next?
Position 2, Baldwin.
All right, good afternoon, Mr. Baldwin. Your case is 22 CR 0018022Y, and what you're charged with simple battery, family violence, hindering a person making an emergency call, and theft by taking, each with an offense date of March the 29th. Do you understand your constitutional rights?
Yes, ma'am.
And can your attorney assist you by video? And can I conduct this hearing by video?
Yes, ma'am.
Thank you. Mr. Howard, second arrest, will you put it on the record, please?
The way, who are we on?
Position 2.
Baldwin.
Okay. Second arrest, last was 2016. Possession of meth, 2 counts. 1 count sale of marijuana, and 1 count of misdemeanor possession of marijuana. Those were dismissed. Except for the misdemeanor, he got 12 months probation for that in 2017.
Okay, thank you. Ms. Tortorello.
Yes, Your Honor. For the simple battery family violence charge, the state's recommending a $3,500 surety bond. For the theft by taking, a $2,500 surety bond. And for hindering a 911 call, a $1,500 surety bond. That'd be a total of $7,500. The condition is that he's have no violent contact with the victim, Miss Noemi Melendez, and that's spelled N as in Nancy, O-E-M as in Mary, I. Melendez is spelled M as in Mary, E-L-E-N-D-E-Z as in zebra. That he take a 1-day anger management class, no drugs or alcohol, and no weapons, and no new violations while out on bond. Your Honor, in this case, the victim, Noemi Melendez, jumped out of a vehicle and ran up to the police officers at Wayfield parking lot located at 3050 Martin Luther King Jr. Drive, Southwest in Atlanta, Georgia. Melendez stated that she was dropping off the defendant, Eric Baldwin, at his job, the incident location, and they were having a dispute. Melendez stated that while she was on a cell phone calling 911, the defendant aggressively struck the victim on the right side of her face and neck. Melendez also stated that during the dispute, the defendant took her iPhone 11 and wallet. Upon arriving to the scene, Officer D. Wilson of the Atlanta Police Department observed the victim run up to his patrol car and observed the defendant attempting to flee in a vehicle. The officer conducted a traffic stop on the vehicle and detained the defendant. Officers retrieved Ms. Melendez's items and returned them to the victim. The officer did read the defendant his Miranda rights and that he was being arrested for simple battery. The defendant then uttered all this over a push and then stated that he should have ran. Melendez and defendant have lived together for 9 years, and that defendant is the father of her child. And all these events did occur in Fulton County, Georgia. Your Honor, I understand, it looks like from GCIC, he only has 2 cycles. However, the state is concerned that he's a flight risk. He did attempt to flee at the scene of the incident, and he even stated to police he should have ran. He has a risk of reoffending. The 2 cycles reflect that he has offended in the past, and 1 was a felony which was dismissed, and that felony was possession of meth. The arrest was made by Marietta PD. Your Honor, also he poses a risk of intimidating the victim here. They do live together. He knows her, and he can potentially intimidate her while out on bond. The state does understand that the victim does want contact, and therefore is the reason why we're okay with a no violent contact. The victim was able to speak to our victim advocate, and she did state that she does want contact with the defendant, and she does feel like he needs some sort of counseling, and she does not fear the defendant. And for this reason, Your Honor, we do feel, given the facts of this case, that a $7,500 surety bond is more than reasonable. Nothing further.
And just clarifying, I know that you just explained it, but the state is requesting no further violent contact and is not requesting any type of stay away, correct?
Correct, Your Honor.
Okay, thank you. At this time, before I go to you, Ms. Gant, I'm gonna sound for the victim last name Melendez, or is it Noemi Melendez? Ms. Melendez, if you would like to speak, I see a Noemi's iPhone. You're not required to make a statement, but if you would like to, this is your chance to do so, but you would need to turn on your camera and unmute your screen. All right, I am not hearing that you would like to, so we're gonna go ahead to your attorney, Ms. Gant. Ms. Gant?
Thank you, Your Honor. Mr. Eric Baldwin is 30 years old. He has been in the Atlanta, Georgia his entire life. He has family here, including 4 children that he shares with the complaining witness, Ms. Melendez. His children ages are 14, 12, and he also has 2 twins, age 3. He informs me that he is the primary caretaker of those children. Your Honor, Mr. Baldwin completed high school. He also has some college credits in business. He states that he is employed at Coca-Cola as a merchandiser and has been in that position for the past year. Your Honor, my client denies the allegations. He denies making any statements to the police. He states that Ms. Melendez handed him the phone, and that the police was aware of this. He also denies striking her. We heard about my client's history. However, we did not hear about any convictions for violence. We heard that he received probation. However, we did not hear about any probation violations, nor did we hear about any FTAs. Therefore, we do not believe that he is a flight risk, given that he has no FTAs and he has sufficient ties to the community. I am requesting a signature bond as he is recommended. If Your Honor is not inclined to grant a signature bond, then a very low bond, as I was able to reach out to his mother, Ms. Baldwin. She states that she will not have anything to help with bond until Friday, and Mr. Baldwin, given his responsibilities with his children, has very limited resources as well. So therefore, again, I am requesting a signature bond or a low bond on Mr. Baldwin's behalf. And we are unopposed to the no violent contact order, as I also had the opportunity to reach out to Ms. Melendez, and my client, Mr. Baldwin, also wants to continue contact, Your Honor. Thank you.
Thank you. Ms. Melendez, I believe I see your hand is raised, and I'm assuming that you would like to say something. If you could try to make your camera and screen work, this is your opportunity for us to hear from you before I issue my decision. All right, while Miss Melinda is trying to figure that out, is there anything further from either party?
Nothing further, Your Honor.
Anything further from the state?
Nothing further, Your Honor.
All right, at this time, Mr. Baldwin is going to receive a $10,000 signature bond through pretrial services. He is broken down, actually 10,000 is probably not the best because of my math. But I'll divide it. It'll be 5,000 on the simple battery, 2,500 on the hindering, and 2,500 on the theft by taking, for the total of 10,000. He is to have no further violent contact with the victim, last name Melendez. He is to complete a one-day anger awareness course, and he is to have no weapons, drugs, or alcohol as a condition of this bond. Is there any further questions from either party?
Not from the state, Your Honor.
Nothing further, Your Honor. Thank you.
All right, best of luck to you, Mr. Baldwin. Ms. Melendez, I wanted to give you the opportunity to speak, but we were not able to do so. Hopefully, any questions can be resolved by Ms. Gant.
Mr. Palmer.
All right, who we
Yeah,
have
she's
next?
logging back on if you want. She's trying to log back on now.
Okay, we're gonna keep moving, just.
Next,
Okay,
we have
there we go.
position 15, Mr. Palmer.
Okay. Oh, Miss. Hold on, Mr. Palmer. Miss Melendez, are you able to hear me? Miss Melendez, we've already resolved
I didn't hear it.
Okay, he's gonna receive a signature bond through pretrial services. In the interest of time, if you have other questions, please call Ms. Gant, all right?
Okay,
Thank you.
thank you.
All right, are you Eric Palmer?
Yes, ma'am.
All right, Mr. Palmer, your case is 22 CR 001816E, in which you're charged with one count of simple battery, family violence, with an offense date of March the 29th. Do you understand your constitutional rights? Can I hold this hearing by video today? And can your attorney assist you by video?
Yes, ma'am.
Thank you. Mr. Howard? Mr. Howard?
My bad, I was just talking. 17
Yeah,
total.
we did not hear you. 17
Yeah, I know, I'm
total.
starting over. Last arrest, 2017, simple battery. He has an open battery in state court and simple battery. And a bench warrant as well. Let's see, 2017 failure to appear, NOD. 2014 FTAs for aggravated assault, kidnapping, battery, family violence. Disposition for those was not prosecuted. 2014 simple battery, family violence. 2012 aggravated assault, kidnapping. It was later dead docket. He had a battery and simple battery that was dismissed from 2011. 2010 arrest for 2 counts of battery. And that's it.
Okay, thank you. Ms. Mitchell?
Yes, Your Honor, the state's bond recommendation is going to be a $3,000 surety bond. No further contact with the victim, Crystal, spelled CRYSTL, Palmer, common spelling. A stay away from the address 2595 MLK Junior Drive, Atlanta, Georgia. A one-day anger awareness course, and no alcohol, drugs, and weapons. Your Honor, in this case, the defendant battered his wife, Mrs. Palmer, by punching her in the face in front of the BP gas station located at the MLK address. Mrs. Palmer had a black eye, but stated it happened about a week ago, and she never called 911 regarding the incident. She also stated that the abuse from her husband is an ongoing issue. Your Honor, the defendant is a high risk of reoffending. He does have a violent history. So he has 2 simple battery convictions and a simple assault conviction, which is before the year 2000. However, he does have a slew of violent charges. Although he had not been convicted on them, it does show a serious pattern of violence. Just to touch on it, there's a simple battery family violence 2017, simple battery family violence 2014. kidnapping, aggravated assault, and battery in 2012, simple battery, family violence 2012. Again, simple battery, family violence, battery, and kidnapping in 2011, 2 counts of battery in 2010, and then 3 other simple battery charges prior to the year 2000. The defendant is also a flight risk, being that he does have 4 failure to appears in his history. We are concerned about witness intimidation in this case. Our victim advocate had an opportunity to speak with Mrs. Palmer, and she stated that they had been married for 38 years. So we're concerned that some of these charges that he has on his history was against her. She also stated that she wants no violent contact, but does want to stay away from their residence. Again, being that we are concerned about witness intimidation in this case, she has already stated that this is an ongoing issue. We're going to stick with the no further contact. The state is going to continue requesting the no further contact at this time. She states that she wants a one-time law enforcement escort to retrieve his belongings. She stated again that the defendant has been abusive at least 3 or 4 times in the past, and that when the victim has tried to call the police on him before, that the defendant will hide her phone and prevent her from doing so. So I believe she is on Zoom, but with that being said, that is going to be the basis of our $3,000 surety bond recommendation, Your Honor.
Ms. Mitchell, I just need to clarify, the MLK address is the BP gas, or that's the home that they share together? And is the state requesting to stay away from both or just from their home?
Your Honor, let me double check on that because I don't want to confuse the address.
All right.
Do that at this time. Palmer.
While you're figuring that out, Ms. Mitchell, at this time, Ms. Palmer, if you are present on the screen and would like to be heard, this is your opportunity to speak. As always and stated previously, you are not required to make a statement, but if you would like to do so, this is your opportunity to speak to the court. All right, Ms. Mitchell is going to continue to work on clarifying the state's requested statement.
Yes. So the address, I initially thought it was their home address, but that address is the BP gas station. So we're going to request to stay away from their home address, which it's not listed in the warrant.
Okay, I'll let you take some time to look and see if there's a more specific stay away address that the state is requesting. Ms. Whitfield?
Yes, Your Honor. Mr. Palmer is 56 years old. He has been living in Atlanta all of his life. He has, in addition to his wife, Mrs. Palmer, an adult son who lives here, so he does have some ties to the community. Unfortunately, he has been residentially challenged as of late. He is fully disabled. He experienced a stroke and a seizure at the same time in 2018 that has left his entire right side paralyzed. So he has been unable to work since then. He's in the process of trying to get a disability claim compensated. It's been set up. It's lots of red tape, Your Honor. He is a high school graduate. Before he was paralyzed, he was working as a delivery man and security guard. He does not oppose the no contact, having no contact with Ms. Palmer. He also does not oppose a stay away from either I would say the gas station, but we would request that he still be allowed to return there. But he does not oppose a stay away order from Mrs. Palmer's address. They do not live together anymore, Your Honor. He's also aware of the other 2 cases. I believe he has a bench warrant on. He was under the impression that these cases had been dead docketed, Your Honor, and so that is why he had not appeared. I advised him that every time he had changed his address at some point and he did not receive court notices. So I did advise him that every time he changes his address, he needs to update that with the court, but he does want to resolve those cases as soon as possible, Your Honor. So in light of all that, Your Honor, we would request a reasonable bond, no more than $2,000, especially since he does not oppose not having contact with Mrs. Palmer and has no problem staying away from the location.
All right, thank you. At this time, Mr. Palmer is going to receive a $2,500 surety bond. He is to stay away from the victim's address that will be provided by either the state or the defense. He is to have no further contact with the victim, last name Palmer, and he is to have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further?
Yes, Your Honor, the address for Mrs. Palmer is going to be 3724 Martin Luther King Jr. Drive, Atlanta, Georgia. Nothing further.
Okay, that's the stay away address. All right, I believe that resolves Mr. Palmer's case unless there are any other outstanding issues.
No, Your
If
Honor.
not, best of luck to you, sir. We can move to the next position.
17, Snyder.
All right. Okay, good afternoon. Are you Andrew Snyder?
Yes.
Mr. Snyder, your case is 22 CR 001820G, in which you're charged with simple battery family violence. I am Judge Melanie Williams. I've advised you of your constitutional rights. Do you understand them?
Yes, ma'am.
Can I conduct this hearing by video?
Yes, ma'am.
And can your attorney assist you by video?
Yes, ma'am.
All right, thank you, Mr. Howard, first arrest. So we'll go
Yeah,
straight
hold on.
to- That's not correct?
It is, but I'm gotta tell you about the TPO. So yeah, the
Okay.
TPO that was issued on the 18th of this month, and it expires next year on the 17th of March. And that victim is a Kyle Patnod, something like that. Just so you know.
Can you speak?
Judge, you muted. What'd you say?
Oh, I asked for a spelling of the address of, not the address, spelling of that name, Kyle. What?
Patnaude.
Okay, thank you.
Yeah.
Ms. Mitchell.
Yes, Your Honor, the state's bond recommendation in this case is a $2,000 surety bond, no further contact with the victim, in this case, Mr. Patnod. So that's in reference to the TPO as well, the same victim. A stay away from the address 3062 Bowling, spelled BOLLING, Way, Northeast, Atlanta, Georgia. A one-day anger awareness course, and no alcohol, drugs, and weapons. Your Honor, on January 17th of this year, the defendant battered his live-in boyfriend, Mr. Patnod, by grabbing his arm, causing Mr. Patnod to spill his hot coffee on himself. It started when the defendant confronted him about getting his belongings out of their apartment, and when Mr. Patnod tried to get away by getting in the elevator, that's when the defendant pushed him into the elevator wall and grabbed him by his arm. So based on that, we are recommending a $2,000 surety bond. Nothing further, Your Honor.
All right, thank you. Ms. Whitfield?
Yes, Your Honor. Mr. Snyder is 33 years old. He has lived in Atlanta for about 4.5 years. He is a Lyft driver in the process of finishing his real estate license course. He has a Bachelor of Psychology degree from Miami University in Ohio. It is true that he and Mr. Patnode do not live together anymore. He would not oppose a no contact and stay away. He has, in addition to this, yes, he did advise me about the TPO that exists between himself and Mr. Patnode. He is honoring that TPO, Your Honor. He is aware that he does not need to contact him. We'd be asking for a signature bond in this case, given that it is his first arrest, and that he would like to complete his licensure course and move on as quickly as he can to continue the progress that he's been making, but also to come back to court. There are some issues that we discussed with video footage that he would like to see, and he would like to get all of his case together, Your Honor. So again, we're asking for a signature bond through pretrial. I believe they did say he was eligible, so that would be a request.
Yes.
Okay.
All right. At this time, Mr. Schneider is going to receive a $5,000 signature bond through pretrial services. He is to have no further contact with the victim, last name Patton. He's to take that 1-day anger awareness. He must stay away from the address on Bowling Way. If he has any items there that he hasn't retrieved and needs to retrieve, he can return one time with a member of law enforcement to get those items.
And Your Honor, sorry to interrupt, but Mr. Snyder informed me that that's actually a commercial address. That's actually, that was not the residence they shared together. That's his,
okay,
Mr. Patton's work address.
Does anyone have the address? Does anyone have the actual address for where the victim resides? That's the stay away out order. He's stay away from that address. And if anything is there, he needs to return one time with law enforcement to get those items.
And I do not have that address, Your Honor, but he does not have any items there. He has completely moved out for 2 months now.
Well, he must stay away from the victim's address as well as the incident location. All right, I believe that will conclude his case. We can move to the next position.
Hi, Gibson.
All right, good afternoon, Mr. Dixon. Your case is 22 CR 001806C, in which you're charged with simple battery family violence with an offense date of January the 4th of 2022. I'm Judge Melanie Williams. Do you understand your constitutional rights?
Yes, ma'am.
Do you object to the video hearing?
No, ma'am.
And do you object to your attorney assisting you by video? Can your attorney help you by video today?
Yes, ma'am. Yes.
Thank you, Mr. Howard.
Third arrest. Last arrest was December 2020. Misdemeanor possession of marijuana. Driving on suspended registration. Suspended registration was, he was given 12 months probation for that, and the marijuana, but the marijuana was later dismissed. May 2020, aggravated assault out of Valdosta, and that appears to be open.
Okay. All right, thank you. Ms. Tortorella?
Yes, Your Honor. We're recommending a $3,500 surety bond. The conditions is that he have no contact with the victim, Tanatika Anderson. Her first name is spelled T-A-N as in Nancy, A-U, T as in Tom, I-K-A. To stay away from the 943 Greenwood Avenue address, Northeast, apartment 5 in Atlanta. 1-day anger management class. No weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, in this case, the defendant attempted to strike the victim, Tanatika Anderson, with a belt because she would not get out of the car. This occurred on January 4th, 2021, when Officer D. Davis of the Atlanta Police Department responded to 943 Greenwood Avenue Northeast, apartment 5 in Atlanta. Upon the officer's arrival, he spoke to the victim, who stated her boyfriend, defendant Marquis Dixon, attempted to hit her face with a belt because she was taking too long to get out of the car. The victim said that the belt missed her by a few inches, but when she attempted to get her 8-month-old out of the vehicle, the defendant pushed her. The victim advised that the defendant has hit her in the past. However, she has never reported it. The victim also advised the officer that the defendant was on probation at the time of the incident and has 2 handguns. The victim and the defendant share a child together, and all these events did occur in Fulton County, Georgia. Your Honor, we do fear that he is a flight risk. He had an FTA out of Cook County in 2020. He does pose a risk of reoffending. He has possible open cases, one out of Valdosta, Georgia for aggravated assault, as you've heard from pretrial. He has 3 cycles, and though not much, Your Honor, one does include a felony. And we do fear that he will intimidate the victim. The defendant knows the victim and knows where she lives, and they do share a child together. For this reason, Your Honor, we do feel that a $3,500 surety bond is reasonable for this matter. Nothing further from the state, Your Honor.
Thank you. All right, Ms. Gant.
Thank you, Your Honor. Mr. Marquis Dixon is 21 years old. He has been in the Tifton, Georgia area his entire life. He shares a 10-month-old with Miss Tanotica Anderson. Your Honor, we are unopposed to a stay away at 943 Greenwood Avenue. He states that he is not familiar with that address whatsoever. Mr. Dixon completed 12th grade. He is also a veteran. He served in the Air Force, and for that service, Your Honor, he is disabled. He is service connected 90% and has been so for the past 2 years. Your Honor, he denies the allegations. He also advised me that regarding the May 1st, 2020 case that's in Valdosta, Georgia, he advised me that that case was reduced to a misdemeanor and that he is on probation for that offense, and it does not involve Ms. Anderson. In fact, he states that in that matter, he was actually defending Ms. Anderson. We did not hear about much more in the area of violence, Your Honor. I am requesting a signature bond on Mr. Dixon's behalf. If Your Honor determines that he is ineligible, then a bond of no more than $1,000. We are opposed to the no contact order. I was able to make contact with Ms. Anderson. She states that she prefers no violent contact. I am not sure if she's on the call. If the court is unable to hear from her, then we will defer to the court's ruling regarding the contact order. And lastly, if Your Honor orders a no contact order, I would ask that Your Honor grant a third-party transfer. Thank you.
Thank you. Let's clarify, what is the stay away address, since I'm hearing that the defendant has never heard of that address, Ms. Tortorello. I want to make sure that the address that you're requesting is actually a relevant address.
Yes, Your Honor. What the police report stated was an 943 Greenwood Avenue Northeast, apartment 5. I can go in Odyssey and double check.
Okay.
And Your Honor,
I'm happy to issue a stay away address from, as listed, but I want to make sure that it actually serves its purpose. At this time, Mr. Dixon is going to receive a $2,000 surety bond. He is to have well, let me sound for the victim, last name Anderson. Ms. Anderson, are you present at the screen on the screen? If you would like to make a statement, this is your opportunity to do so. Ms. Anderson, if you are present, you would need to unmute. All right, hearing none, I'm gonna order that he have no further contact with the victim, last name Anderson. He can arrange transport of his child via third party if necessary. He is to stay away from the victim's address. I'm presuming it's at Greenway Avenue. And he is to have no weapons, drugs, or alcohol as a condition of this bond. If he has any weapons, he'll need to surrender those. Are there any questions or comments from either party?
Your Honor, the police report has, it's a little confusing, but this is what the officer put: 943 Greenwood Avenue Northeast, 800 Frederica Street Northeast, and 800 Barnett Street Northeast. I believe that was just where the incident they reported to, Your Honor. I am going to stick with the 943 Greenwood Avenue Northeast, apartment 5 in Atlanta.
All right, we'll go with the stay away as requested by the state. I'm just hoping that that address is relevant, as we've heard from Ms. Gant. He doesn't know what that address is, but we will go with the addresses given by the state.
And
all right.
Your Honor, and to add, if there's a no contact with the victim, that will also assist as well.
There is a no contact provision. I just wanted to be clear, and he can arrange for the third party transfer of the child. All right, if there's nothing further, best of luck to you, sir. Can we move to the next position?
Position 10, Haddon.
All right, Mr. Haddon, Your case is 22 CR 001811B, in which you're charged with battery, family violence, and criminal trespass, damage to property with an offense date of February the 20th of this year. Do you object to the video hearing today?
No, ma'am.
Do you understand your constitutional rights?
Yes, ma'am.
And can your attorney help you by video?
Yes, ma'am.
Mr. Howard?
15 total. Last arrest was on the 26th of this month for a suspended license. He went to the city jail for that. 2018 criminal trespass conviction. It was a simple battery, family violence with that arrest. I'm not sure what happened with the charge, and a criminal damage to property, 2nd degree. I got a robbery, simple battery, theft by taking, sexual battery from 2018 out of Gwinnett. Those were dismissed. 2016 misdemeanor obstruction, misdemeanor possession of marijuana, arrest. 2014 failure to appear, giving false name. 2014 probation violation, underlying charge was burglary. 2013 probation violation, failure to appear, conviction. Giving false name, conviction. 2013 shoplifting, conviction. 2013 probation violation, burglary. 2012 probation violation. And it came off
Did you
of
say he had any open cases? I'm sorry, was there anything open right now? Did you say open case?
Well, I no.
Okay.
I mean, the
I wanna
suspended
make sure.
license is probably open at the city, but I don't see nothing else.
Okay.
That I
Okay,
know
I'm
of.
sorry. Keep going. Keep
I'm just-
going.
That was it.
Okay. Thank you so much, Miss Mitchell. I apologize. It's getting late. Long day.
Yes, I agree. The state's bond recommendation as to count 1 is $3,000 surety, as to count 2, $2,000 surety, so totaling a $5,000 surety bond. No further contact with the victim, Miss English, spelled Inglish, Hills, common spelling. Stay away from the address 3360 Desert Circle, apartment 9, East Point, Georgia. A 1-day anger awareness course, and no alcohol, drugs, and weapons. Your Honor, in this case, the defendant battered his girlfriend at the time, Ms. Hills, by punching her in the face, causing a reddish mark on the left side of her face. The defendant also picked up a patio table and threw it at Ms. Hills' vehicle, damaging the rear windows of said vehicle. It started when they were out celebrating Ms. Hills' birthday, and she didn't want the defendant to drive intoxicated. During an argument about defendant wanting to have sex and Ms. Hills not wanting to, the defendant punched Ms. Hills in her face. The defendant then exited her residence, and began damaging Ms. Hills' vehicle by throwing a patio table he bought her at her vehicle. Ms. Hills informed officers that she wanted to file a restraining order against the defendant. She was upset and didn't feel safe at the time, so much so that she requested that the officers remain on scene for an hour to make her feel safe. There is footage of the incident on her Ring doorbell camera. Your Honor, as you've heard from pretrial, the defendant does have an extensive history in that he has 2 convictions for criminal trespass in 2018 and a conviction for burglary in 2012. We are concerned that the defendant may also be a flight risk, being that he has 3 failure to appears and 4 probation violations. Your Honor, our victim advocate had an opportunity to speak with Ms. Hills, and she stated that they're no longer in a relationship and that she does not want to live with him any longer. Ms. Hill stated that the defendant contacted her one time after the incident, threatening to call her school and her apartment building. She stated that the defendant did call her school, which is Spelman College, accusing her of committing PPP fraud. And she did confirm that she had damage to a car totaling the window was $175, another window was $75, and then $50 to install. So based on that, Your Honor, we are recommending the $5,000 surety bond, nothing further.
Thank you, Ms. Mitchell. Miss Whitfield.
Yes,
before I go to you, Ms. Whitfield, I'm sorry, I'm actually gonna sound for the victim. Ms. Hills, if you are present on this Zoom conference, This is your opportunity to speak if you are present. Ms. Hills, would you like to make a statement?
Yes, Your Honor.
All right, please raise your right hand as you see me request of other witnesses. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
Yes, ma'am.
What would you like to tell the court today? You put your hand down.
Yes, ma'am. I'll make it very brief. I have known Deshaun for prior to 2 years, and previously we've had an up and down relationship, but never has it been to this degree. I truly believe in rehabilitation, and I know that he has some financial constricts that would probably allow him to not be able to pay a bond. I'd hate to see him sitting in jail without, being able to work on himself. I'd like if he can possibly just maybe do some type of courses and maybe like a low bond to have the opportunity to kind of rebuild himself. I think this situation really occurred just due to him kind of not knowing how to manage his anger very well. I don't want anything to do with him. I don't want him to contact me, come to my school or my apartment or anything, but I would hate to see him, I guess, sitting in pretrial holding just due to not being able to financially afford to be released. And in light of that, I would love to just see him being able to rehabilitate in some type of sort of program that'd be beneficial to him, just to kind of help him grow and develop as a man as well.
Thank you for that perspective, Ms. Hills. I do appreciate you speaking today. All right, Ms. Whitfield.
Yes, Your Honor. Mr. Haddon is 28 years old. He has spent the last decade or so in Georgia. He is a high school graduate. He works now at Classic Tents and Events for about a month, but prior to that, he was a forklift driver at a Walmart distribution center here in Atlanta. His mother and sister both live here in Atlanta, so he does have community ties to ensure his return to court. He is not opposed to having no contact with Ms. Hills. He is also not opposed to staying away from her apartment as a condition of bond. Your Honor, we're asking for as low a bond as possible in his case, as you heard from Ms. Hills, to give him. We would also like to ask Your Honor to allow him an opportunity to take some courses or do something that also does not involve Mr. Haddon sitting in jail for the foreseeable future. He does work very hard, and he does want an opportunity to be out and to reappear for this particular offense, Your Honor. So, like I said, we'd be asking for a reasonable bond, no more than $2,000 total, $1,000 for the battery, family violence, $1,500 for the battery, family violence, and $500 for the criminal trespass.
Okay, Mr. Haddon is going to receive a $2,000 bond as delineated by Ms. Whitfield, $1,500 for the battery, family violence, $500 for the criminal trespass. For the total of that $2,000, he is to have no further contact with the victim, last name Hills, and he must stay away from that address on Desert Circle. He is to have no weapons, drugs, or alcohol as a condition of this bond.
That's a good
Is there
bond.
anything? That's a good bond. All right. Anything further?
No, Your Honor.
Nothing further, Your Honor.
All right. Best of luck to you, sir. Who do we have next?
Position 9, Gibson.
Okay, Mr. Gibson, your case is 22 CR 001812A, and you're charged with obstruction of a law enforcement officer with the offense date of March 21st of 2020. I've been through this. I want to make sure that you understand your constitutional rights. Do you understand them?
Yes, ma'am.
Do you, are you okay with this video hearing and your attorney assisting you by video?
Yes.
Okay, thank you. Mr. Howard.
14 total. History out of Georgia and North Carolina. Last arrest was March 21st. Failure to appear. Before that was April 2021, felony shoplifting. November 2020, felony shoplifting. He got 2 open shopliftings in Superior Court. 2020 probation violation out of Gainesville. 2017 possession of meth. Driving without a valid license conviction. 2011 theft by receiving, dismissed. Go to North Carolina real quick.
I think that's relevant.
Okay.
Go ahead and pull up the North Carolina. If it's in the past 5 years, let's limit to that.
Well, it's 6 years.
Okay, I think, go ahead and give it to me since you proposed it.
It's trespass 2015, second degree conviction. Misdemeanor larceny conviction 2015. It was a felony. They reduced it to misdemeanor. That's it.
All right. All right, thank you, Ms. Mitchell.
Yes, Your Honor, there's a current bond of $1,000 surety on this case, and the state requests that the bond be increased to $2,000 surety with a stay away from the address 2645 Old Milton Parkway, Alpharetta, Georgia, and no alcohol, drugs, and weapons. Your Honor, in this case, the defendant obstructed Officer T. Maloney's, spelled Malloni, duties by resisting arrest. The defendant pulled away from the officer in an attempt to not be placed in custody and refused to obey multiple verbal commands to stop resisting arrest from said officer. The defendant was found sitting on the curb of the back parking lot of Racetrack with 2 active warrants at the time, one in Fulton and one in Cobb County. Your Honor, you've heard from pretrial defendant's history. He does have 2 open cases for theft, and then 1 in Alabama in 2019 for stolen property. We are concerned that the defendant may be a flight risk, being that he has 2 failure to appears this year. So based on that, Your Honor, we are requesting the increased bond for $2,000 surety, nothing further.
And the current bond is 1,000?
Yes.
Okay, thank you. Ms. Gant?
Thank you, Your Honor. Mr. Michael Gibson is 33 years old. He was born in Decatur, Georgia. He has been in this area his entire life. He has family in the area also. Your Honor, we are unopposed to the stay away order at 2645 Old Milton Parkway. Mr. Gibson completed high school. He also has college credits in the area of heating, HVAC. He has been unemployed for the past year, Your Honor, so he does not have the ability to pay anything toward bond. Therefore, I am requesting a signature bond on his behalf. He disputes the allegations, and we heard about his background, but Your Honor, we do not hear any convictions for violence, and the allegation is that there is no allegation that Mr. Gibson offered violence. So again, for these reasons, given the nature of the allegations and his limited financial means, I am requesting a signature bond, Your Honor. Thank you.
All right, thank you, Ms. Gant. Mr. Gibson's bond will remain as set at $1,000 surety. He must stay away from that address on Old Milton Parkway and have no weapons, drugs, or alcohol as a condition of this bond. Are there any further questions?
No, Your Honor.
How much was that?
I'm sorry, Mr. Howard.
How much?
It's gonna remain at the $1,000 where it was previously set. All right, best of luck to you, sir. Who do we have next?
Judge, real quick, he has a theft by shoplifting. That's on his 3 card, but
I think that's a bench warrant. Is it 21 CP?
Yeah, 21.
Yeah, it's a bench warrant.
Okay.
Yeah.
All right.
All right, Judge.
And I'm assuming
there in courtroom 2.
position 8 is not there.
I'm trying to. Okay, we got one more. I guess I was. Go ahead, have a seat. My bad. Yes, position 8, Mr. Furtick. Is that how you say it?
Okay. All right, Mr. Furtick, your case is 22 CR 001810D, and what you're charged with simple assault, felony violence, and criminal trespass with the offense date of the 29th of March. You understand your constitutional rights?
Yes, ma'am.
And can I do this by video and your attorney can speak by video?
Yes, ma'am.
Thank you. Mr. Howard?
I counted about 11. History out of South Carolina, Florida, and Georgia. He's a resident of Orangeburg. I'll start with Georgia first.
Okay.
December 2020, criminal damage to property, second degree. It was amended to trespass. That's open in state court in Douglas County. January 2022, South Fulton, disorderly conduct arrest. 2010 arrest in Florida for giving false name, that was dismissed. South Carolina, 2010 strong arm robbery, common law robbery conviction. 2012, same thing. 2012 violation of probation. 2013 violation of probation, 2013 burglary second degree, possession of a weapon during a violent crime conviction. The next cycle is a 2014 armed robbery with deadly weapon, burglary second degree, possession of a weapon during a violent crime. Those convictions. That's all I have.
I got a question. With those convictions,
I don't want you to say anything. Please don't say anything. Anything you say cannot be used against you. The state is listening, all right?
Okay.
Let Ms. Gant speak for you, and if there's anything that comes up, she's gonna do her job to protect your interests, all right? Ms. Mitchell?
Yes, Your Honor, in this case, we're recommending as to count one, a $3,000 surety bond, and count two, $2,000 surety bond, totaling a $5,000 surety bond. No further contact with the victim, Tariqua, spelled Tyricqa, Walden, spelled Waldon. A stay away from the address 1212 Utoy, spelled Utoy, Springs Road, Southwest, South Fulton, Georgia. A one-day anger awareness course, and no alcohol, drugs, and weapons. Your Honor, in this case, the defendant assaulted his ex-girlfriend he used to live with, Miss Walden, by brandishing a kitchen chair. The defendant also damaged multiple walls of Miss Walden's apartment by striking said walls with that same kitchen chair. It started with a verbal argument that escalated when the defendant became increasingly angry, grabbed the kitchen chair in an offensive manner, and told her to, quote, shut up. Out of fear of being struck, Miss Walden stayed seated. At this point, the defendant began striking and damaging the walls inside of her apartment using the kitchen chair. After some time had passed, Miss Walden felt it was safe enough to leave. She drove to the gas station and called 911. The officer observed multiple holes in the walls of the residence and a shattered coffee mug on the bed of Miss Walden and the kitchen chair that was used by the defendant. Your Honor, you heard from pretrial about defendant's history. Just to highlight the violent ones again, he's been convicted of possession of weapon during a violent crime in South Carolina in 2014. He was convicted again for that exact same crime with an additional burglary charge in 2014. And then he was convicted of robbery with deadly weapon, 2 counts of that in 2012, all of those in South Carolina. Your Honor, it looks like he has 2 open cases, a disorderly conduct from this year in South Fulton and a damage to property felony out of Douglasville from 2020. There's also concerns of him being a flight risk, being that he was arrested for being out-of-state fugitive back in Florida. So based on that, we are recommending the $5,000 surety bond. Nothing further.
All right, thank you. At this time, I'm going to sound for the victim, last name Walden. Ms. Walden, if you are present, this is your opportunity to speak. All right, hearing and seeing none. Go ahead, please proceed, Ms. Gant.
Thank you, Your Honor. Mr. Nicholas Furtick is 31 years old. He was born in Orangeburg, South Carolina. However, he has been in the Atlanta area for the past 8 months. He has community ties here, including cousins and aunts. He is also gainfully employed as a contractor agent where he manages 200 people, and he is desperately wanting to get back to work so that he can secure that position. Your Honor, we are opposed to the stay away at 1212 Utoy Springs Road Southwest. I was able to reach out to Ms. Walden. She states that she does want to continue having contact with Mr. Furtick, as does my client. Mr. Furtick completed the 10th grade. He also has 1 year of college credits in the area of business management. He denies the allegations. Well, Your Honor, he disputes the allegations. He states that she wasn't nowhere near him during that time. I acknowledge my client's history, but I would point out to the court that the violent convictions are almost 10 years old, and we believe that those are too remote for this court to consider. My client has taken great efforts to reform himself, and we just do not believe that he is a flight risk, Your Honor. He has open cases. However, he is presumed innocent in those cases, as he is in this case as well. If Your Honor is not inclined to grant a stay away, if Your Honor orders a stay away, we are then requesting a one-time law enforcement escort. And again, we are requesting a signature bond, Your Honor, and if Your Honor determines that he is ineligible, then a bond of no more than $500 for each count. 500 for simple assault, family violence, 500 for the criminal trespass, for a total surety bond of $1,000 if he is in fact ineligible for a signature bond. Thank you.
Thank you. Because the victim was not present here today, Ms. Gant, I do not feel comfortable with not issuing that stay away. So he is gonna have to stay away from that address on Utoy Springs and have no further contact with the victim. He will receive a surety bond as follows. On count one, it's going to be $1,500. Count two, $500, for a total of $2,000 in surety. And he is to have no weapons, drugs, or alcohol as a condition of that bond.
Thank you, Your Honor.
Thank you, Your Honor.
All right. I believe that concludes our calendar. Ms. Middlebrooks, will you please review it for me?
All right, Judge, we're completed here in courtroom 2. Thank you.
Thank you. You can be excused. Have a great afternoon. Take care.
Thank you. You do the same.
Okay, bye-bye.
Okay, position number 1 is a $3,000 sign-on bond through pretrial, reset further notice. Position number 2 is a $10,000 sign-on bond through pretrial, reset further notice. Position number 3, $5,000 sign-on bond through pretrial, reset further notice. Position number 4, $2,000 sign-on bond through the jail, reset further notice. Position number 5 is a $2,000 good bond, reset SAP, April 12th. Position number 6 is a $1,500 good bond, reset SAP, April 12th. Position number 7 is a $2,000 sign-on bond through the jail, reset further notice. Position number 8 is a $2,000 good bond, reset SAP, April 12th. Position number 9 is a $1,000 good bond, reset SAP, April 12th. Position 10, a $2,000 good bond, reset at SAP, April 12th. Position 11 is a $15,000 good bond, reset April 12th. Position 12 is a $7,500 good bond, reset SAP, April 12th. Position 13 is a $1,000 good bond, reset SAP, April 12th. Position 14 is a $1,500 good bond, reset SAP, April 12th. Position 15 is a $2,500 good bond, reset SAP, April 12th. Position 16 is a $1,000 good bond, reset SAP, April 12th. Position 17 is a $5,000 sign-on bond through pretrial, reset further notice. Position 18, a $5,000 sign-on bond through pretrial, reset further notice.
Are there any questions, comments, changes, corrections?
I have a question for position 12. I had a good bond of 7,500. Is that?
That's correct.
Okay. Thank you.
Thank you, Ms. Middlebrooks, for being aware, because I cannot read what I wrote. All right, I believe that will complete this calendar. We will all be in recess until tomorrow at 2 p.m., at which time Judge Law will be presiding. I don't believe I'll see any of you for the rest of the week, so take care, enjoy the rest of your week, and have a good weekend, everyone. Bye-bye.
Thank you,
Thank
Judge.
you.
You too.
Oh, and any outstanding paperwork, please send to Ms. Middlebrooks for my signature. It shouldn't be anything today, as I don't believe we sent any MHs, but if there's anything, please send it to her. All right, take care, everyone. Bye-bye.
Good one, Judge.